All right. So as you can see from your screen, I'm Judge Edwards. We have Judge Eisnagel and Judge Grosshands. For appellant, if you would like anything other than 5 minutes rebuttal, please let me know. Otherwise, you can see the clock in one of the windows there and follow along. When the yellow light comes on, that means you're into your rebuttal time. When the red light comes on, that means that it's time to stop. Do you need anything other than 5 minutes?
No, Judge. Thank you.
You proceed.
May it please the court. Good morning. My name is Sam Alexander, and I represent the appellant, Timothy Viens, in this case. In this case, Mr. Viens was unable to defend himself against Mr. Land's claims for civil theft, unjust enrichment, and conversion because evidence that was necessary to his sole defense was erroneously excluded. And for that reason, we're asking that this court reverse and remand for a new trial. I think the best way to think about the defense in this case is almost like an alibi, which is a defense that is not an affirmative defense because it doesn't admit liability and seek to excuse it, but is a story that is told that tends to negate material elements of a charge. So, for example,
so could you clarify exactly what evidence or what testimony did not come out at trial that you claim should have come out? The exact testimony that you claim should have been allowed.
The testimony would have been that there was an agreement between Mr. Land and Mr. Viens in which Mr. Land was going to invest $500,000 into a company in exchange for a percentage of equity in that company.
It was the $500,000 amount that did not come out at trial, correct? That was the specific fact.
And that fact led to other facts, such as the fact that the $500,000 was for equity in the company. So he was stopped as soon as he started testifying as to the $500,000. But as the affidavits show, and as the trial judge kind of
was testified to, right? There were two amounts that were testified to, correct?
In terms of what, Judge?
Well, there was the truck, right?
Yes.
And truck and trailer, how much was that?
That was $105,000.
That did come out at trial, correct?
Yes.
Okay, what was the other amount?
The $100,000.
Right.
And then there was actually a third amount as well.
That came out at trial?
Yeah, there was the $110,000 for the used race cars and various equipment.
So why was it important that, so it's, at least 200,000, if not 300,000 came out at trial. Why was it important that your client be able to testify to the 500,000?
It was less the particular number, and it was more how the number related to all of the other numbers. So the $500,000 was consideration for equity in the company. And so Mr. Viens' theory of defense was that all of these individual transactions were not in fact individual separate transactions, but were instead part of an overall larger transaction.
He actually testified to that, right, at trial, if I recall correctly?
I don't believe so. He was not given the opportunity. He testified that the truck and the trailer were for a race team. Right. He testified that the $100,000 was for him personally, but it was
still for the race team. He testified that the parties had agreed to start a race team, correct?
Yes, but he was not allowed to testify as to the details of the agreement.
And I guess what I'm trying to find out is very specifically the details that were left out. I mean, I think we can agree that some details of the agreement here were testified to by your client, and then some weren't, right? So the details that weren't, the fact that it was a $500,000 agreed investment as opposed to $200,000 or $300,000. Why did that specific fact matter?
Because that fact explained what the consideration was for the agreement. Without explaining what Mr. Land's investment was, it's very difficult to explain what the actual agreement was. And so the $500,000 is a stepping stone to the fact that that was going to be inputted into the company in exchange for equity. And the $500,000 was going to be, there was going to be individual investments by Mr. Land that added up to that amount. And that explains.
But your client testified that there was an agreement to start a race team and that the purchase of the truck and trailer was an investment in that race team, correct?
Yes.
And that the extra $100,000 that went to your client was part of that agreement, correct?
I believe so, yes.
Okay. So I guess what I still don't understand why the $500,000, what the $500,000 would add to the story that the testimony that did come out doesn't accomplish.
I think that there's a difference between saying we had an agreement to start a race team and these were part of that agreement, and saying, here are the details of our agreement to start a race team.
Well, tell me what the difference is.
The difference is that the $500,000 was specifically intended to purchase a specific amount of equity in the company. That was never testified to. And
why did that matter?
That matters because it relates to the fact that the individual purchases were the capital contribution of Mr. Land toward that overall investment, toward the equity. It explains how the deal operated. In addition to that, Ms. Aitchison was going to testify as to the specific amount, the $500,000, as shown by her affidavit.
The purchase of the truck and trailer, the $100,000 that your client called a good faith sort of investment, those didn't accomplish the same goal of telling the finder of fact, hey, look, we had this agreement to start a race team, and this was an investment into the race team?
No, I don't think so, because he wasn't allowed to explain how the overall agreement worked. He said, yes, he said that each of the individual transactions this was supposed to be part of the race team. This was supposed to be part of the race team. But what was the actual agreement for the race team? That was never.
And but counsel, you keep saying that, but you haven't told us why that matters. What does that add? Okay, so the finder of fact knew that the investment was, let's say, $200,000 plus. What would it add for them to know that, okay, well, the agreement was for $500,000?
Well, first of all, it has explanatory power in terms of it's subsuming all of these individual transactions under the umbrella of a greater contract. And that relates to negating a claim for civil theft in the first place, because a claim for civil theft is not proper when the property at issue is governed by an overall contract. So explaining it lends
credibility. But your
credibility.
client said that there was an overall contract, right? He testified, look, we had this agreement to start a race team.
But he was prevented from explaining the details of it. And I think the fact that he couldn't say $500,000 and that Ms. Aitchison couldn't say $500,000 reduces the credibility of his defense, because he would have had corroborating testimony. He would have said, here is an agreement for a race team, and here are the details of it, the precise details. And Ms. Aitchison would have testified, I also was aware of an agreement, and here are the precise details of that agreement, and they would have matched, as shown by the affidavits. Instead,
wasn't part of the reason that the judge didn't permit that is it was the statute of frauds issue. Wasn't that part of it?
That was part of it, and
this is a two-part question. Another part was because there were not any affirmative defenses pled, and you raise in your brief you don't think these are affirmative defenses. In essence, Mr. Land pled, you took that $100,000, and your client's answer is, yes, I did, but I was allowed to because of the deal. Why is that not an affirmative defense? That's his only justification for taking the money, is there was a deal. So wasn't it incumbent upon him to prove the deal?
So Mr. Land was required to prove as part of his claim not only that Mr. Vians took the $100,000 and took the truck and the trailer, but that Mr. Land owned the truck and the trailer himself, and that Mr. Land was entitled to the $100,000, and that Mr. Vians had the intent, that Mr. Vians knew that Mr. Land owned the truck and the trailer and knew that Mr. Land was entitled to the $100,000 and took them anyway. But Mr. Vians never admitted any of it.
When Mr. Land asked for an accounting on the $100,000, Vians didn't say, I don't need to tell you that because it's my money. He just refused to respond is what the proof was, I thought.
I think that there was differing testimony as to who broke down communication, because Mr. Vians testified at trial that he tried to communicate with Mr. Land and he didn't receive any communication. But
right, but the trier of fact heard that and resolved that. You would have to presume resolve that in favor of Lands and against Vians.
I think they did that without the benefit of being able to hear Mr. Vians' theory of his defense. Even
if there was a deal, and there was supposed to be a race team, as everybody discussed, how is it that all of a sudden one member of the race team gets to sell the truck hauler and trailer and keep all the money?
That's a good question, but the issue is Mr. Land's claim for civil theft was predicated on the fact that he owned the truck and the trailer. It's a different type of claim if you're saying the company owned the truck and the trailer and Mr. Vians should not have sold it and benefited from that personally. That's a claim that maybe should be brought by the company against one of its owners. But I don't
let me discuss with you the fraudulent conveyance judgment against Connecticut Trees, okay?
Yes, sir.
Do you disagree that it was a fraudulent conveyance in terms of there was money transferred to Connecticut Trees for no consideration? You would agree with that part of it, correct?
Well, so the fact of it being a fraudulent conveyance depends on the jury's finding that there was unjust enrichment and civil theft and conversion. Mr. Vian's position.
Just in terms of the conveyance, when Land conveyed the $40,000 to Connecticut Trees, there was no consideration from Connecticut Trees to not to Land, I'm sorry, to Vians. There was no consideration between them for that $40,000. Vians just transferred it to Connecticut Trees, correct?
Yes, but he believed it was his money.
Okay, but the purpose for transferring it, if the judge found, was to defraud a creditor, in this case Land, doesn't that then complete the fraudulent transfer?
So we will obviously concede that the judge found that it was a fraudulent transfer. And so that's not really the issue even with that we're raising on appeal.
Top of everything else, is that correct?
Yes, Judge, yes.
And what it should be, if you accept the judge's ruling, which you have to, I guess, it should be $40,000 as part of the overall judgment.
Precisely.
So the fact that it was a fraudulent conveyance may be sustainable, but the form of the judgment just needs to be amended so that it's not an additional $40,000, but part of the overall judgment.
Exactly. So the way that, we try to frame it in the brief is if the damages are $105,000, leaving aside the trebling, and the truck and the trailer are sold, and a portion of the proceeds are, let's say, for the sake of argument, fraudulently transferred to someone else, that doesn't increase the amount of compensatory damages suffered by the plaintiff. And if, let's say, the funds were transferred again, you wouldn't tack on another $40,000 every time it was transferred. The damages amount stays the same. The purpose of the fraudulent transfer statute is to basically, attach to an asset and say, you've received this asset, now you are jointly liable for the damages in this case. And that's what happened in the USEM case, where
so if Land is able to recover the total judgment just between him and Viennes, then the Connecticut Trees judgment should go away, correct?
Precisely, and that's what it says. You know, the answer brief kind of concedes that issue when it says, you know, the only possibility of there being an overpayment is if Mr. Viennes actually pays and Connecticut Tree Sales actually pay what they owe under the final judgment. And to our mind, that's almost a concession that the terms of the final judgment contemplate an overpayment. And so that we would ask this court to correct that. And I'd like to
Run through
reserve
your
the rest of
rebuttal
my-
time. Do you want to save that? Okay.
Yes, please.
All right. Ready for the appellee.
Thank you, Your Honor. Lisa Patton on behalf of the appellee, Scott Land. I've been listening to opposing counsel's argument here, and in his briefs, as you can tell, his primary argument is that his clients did not have the ability to provide any defense to the claims brought in this case because of the rulings of the lower court, both before the trial and during the trial. And I disagree with Mr. Alexander, with all due respect, but he's wrong. The trial transcripts and the record show clearly that the defendants in this case were able to defend these claims and just procedurally failed on many avenues and fronts. Let's look at the first one. Judge Orfinger properly granted motion for summary judgment in my client's favor because the counterclaim that was asserted, which alleged a breach of an oral contract, was barred by the statute of frauds. Judge Orfinger found that. Right before the hearing, the day before the hearing, the defendants filed their memorandum in opposition and submitted 2 affidavits in an attempt to beat the statute of frauds. Judge Orfinger looked at all of the memoranda, the arguments, and the affidavits, and he ruled that those affidavits were untimely and that they should be stricken because the rules are very clear, the procedural rules, that they have to be submitted to opposing counsel 2 days before the hearing. No argument was ever made by counsel for the defendants that there were any type of exigent circumstances that would have allowed for a late filing. That's the type of exception to the notice rule of 1.510. If there is some type of exigent circumstances, like in the Davis case, where counsel withdrew, the defendant had to get a new lawyer, had to hire a new expert, and had no time to timely file affidavits. Nothing like that happened here. And in
Counsel,
fact,
why is summary judgment on a counterclaim? Why does that foreclose why does that make otherwise relevant evidence inadmissible on a different claim?
well, the reason it did, Judge, is because in order to present claims and issues to a jury, they have to be pled. And in this case, they were going to present evidence regarding this oral agreement for a long-term business relationship to the jury. And we wanted to eradicate that claim because it wasn't properly pled and it was barred by the statute of frauds. And
But they did. I mean, but counsel, they did didn't they testify? Hey, look, I mean, we had a deal to create this race team, and the truck and the trailer were part of it, and the $100,000 good faith payment was part of it. It was all, they testified. They said, hey, look, this was all part of a bigger agreement to start a race team.
absolutely, they did testify.
So, and that came in.
That
that
all
stuff came in. So
all of it.
why not? Why is the $500,000 then not, why is that not admissible, right? It's, you know, you were saying, well, they wanted to say that there was this big agreement and all. Well, they did say that, right? What they're complaining about is, but we didn't get to talk about the overall investment that, by the way, 2 witnesses would have testified to. Why is that not admissible then?
The 500,000, Judge Orfinger agreed with me that fact about the 500,000 was the big amount that was to be invested as part of this overall agreement, was so specific to the counterclaim that it needed to be excluded because that claim was dismissed prior to trial, which in fact, it was dismissed one year prior to the trial.
I'll go back to my original question. Why does the dismissal a summary judgment or dismissal of a counterclaim, why does that take evidence that's otherwise admissible on a totally different claim and make that evidence inadmissible?
Well, it wasn't just specifically the granting of the summary judgment that precluded them from talking about this $500,000 oral agreement. It was also their failure to plead that as an affirmative defense, because the rules require that all of the issues and evidence are framed by the pleadings. So as I was going to say, this motion for summary judgment, it was granted 1 year prior to the trial.
What would they have?
Defendants had the
What would they,
ability-
counsel? What would they have pled? I mean, what would their? Tell me what their affirmative defense should have said.
Their affirmative defense should have said that they had an oral agreement that the plaintiff would have invested $500,000, and he failed to comply with that part of the agreement, because that's exactly what they pled in their counterclaim. And they all actually pled that also in their answer and affirmative defenses, but they pled it as a written agreement. And defense counsel at the trial, when I brought up my motion in limine in the very inception, admitted that he, in our pretrial stipulation, said there was no written agreement, so that his affirmative defense number 4, I believe it was not even applicable. What they should have done.
Counsel, doesn't their defense turn on the fact that there was an agreement, an overall agreement, overarching agreement to create a race team? Isn't that the core of their defense here? And I mean, why should it matter if it was a $200,000 investment or a $500,000? The point is that they said, look, we had this overall arching agreement to create a race team, and that's my defense here. Isn't that their defense, not the $500,000? That
is their defense. You're absolutely right, Your Honor. And they did that.
But they didn't need to plead 500,000, right? They didn't need to plead the number. They needed to just say, look, we had an overall agreement to create a race team.
Right. And they were allowed that ability throughout the trial. Mr. Viennes testified to this effect. In fact, it's pointed out in my brief, he and Ms. Aitchison, his primary witnesses, testified over and over that there was an agreement that was reached between them whereby Mr. Viennes and Mr. Land were creating a racing team. And then he testified that the $100,000 that was provided by Mr. Land was a bonus. In fact, he says it was a bonus and it was my money. And then he testified that the truck and the hauler, or the truck and trailer, that were purchased for the company and actually titled in the name of the company.
Counsel, I guess what I'm trying to sort of narrow in on here is that it seems like the $500,000 doesn't go to the core of the defense here. It seems like that's just a detail in it.
It is.
And so my question is should the $500,000 come in? Should the trial judge have allowed that to come in? Maybe it was harmless error, right? But it seems like it would have been relevant to the defense that they did present.
I don't think it was relevant to the defense. I think like what you're saying, Your Honor, is it may have been a minor detail, which was not material, and it was excluded because it related to the counterclaim that had been excluded under the statute of frauds.
Okay, you said that again, but again, I haven't heard a legal argument as to why it should be inadmissible simply because a counterclaim is kicked out on summary judgment.
The judge excluded it under the relevancy rules because I argued that it wasn't.
Which has nothing to do with the counterclaim, right?
Well,
I mean, relevancy has nothing to do with the counterclaim, right?
Not necessarily, no, but I argued two things at trial. I said it was prejudicial to allow that information in. It had already been excluded, and that also it hadn't been pled by them. So if you have the case is framed by the pleadings, you can't just bring in information at the last minute that's not relevant and prejudicial to my client. But notwithstanding that, I mentioned it 4 different times during the trial, the $500,000 amount. And one of the sidebars is on the record where the judge clearly said, just don't mention the $500,000. If that was error, I don't think it was, but it was harmless, if anything, because as Your Honor is pointing out, Mr. Viennes testified on direct through me, on cross-examination through his counsel, then again on direct through his counsel and cross-examination through me. 4 different times he testified that there was an agreement between the parties, and that's why everything he did was justified by this agreement. It didn't matter if it was a $500,000 agreement or $1 million agreement. He was able to testify and defend the claims. In Mr. Alexander's brief, he's talking about, well, Mr. Viennes wasn't able to give his alibi, and he uses that hypothetical. Well, okay, my client's convicted or accused of assault, and his big defense is, well, the alleged victim was holding a gun. Well, Mr. Viennes was able to testify that the alleged victim was holding a gun. The only thing he wasn't able to testify is what type of gun it was, whether it was a Beretta or a Smith & Wesson. It was a minor detail, which I think Your Honor is acknowledging. There was nothing there that he was precluded from testifying to. Both he
Talk about
and Grace
the,
Atkinson- I'm sorry.
Counsel, let's
Judge.
talk about the fraudulent conveyance.
Okay.
Do you agree that the form of the judgment is in error?
Well, I think that it would have been better for the judge to write the judgment in a way where it states that Connecticut Tree Sales is jointly and severally liable for the $40,000. That would have been the proper way to write that judgment, because that's what the fraudulent transfer statute says, that any third party who receives monies that are fraudulently transferred, they're jointly and severally liable to the debtor. And so he didn't write it that way.
The $40,000 would be a part of the overall judgment rather than an additional $40,000, correct?
That's right. And that's why if we wrote it as joint and several, that he's liable, CT Trees is liable up to $40,000 jointly and severally with the defendant Viennes, it would have been proper. But my point is also, until that judgment even comes close to being satisfied, it's kind of an empty argument. There, at any time, CT Trees could try to file a motion to reduce the judgment because it's been satisfied. This is not a fundamental error that creates a substantive reason to reverse. It can be easily addressed post-judgment when we do get to the point where monies are being collected on the judgment.
Well, let me ask you about that. I mean, would the judgment as written clearly be satisfied? Or does the judgment arguably allow for your client to recover, make a double recovery on that, on the $40,000?
Well, if the judgment in this case allowed for damages or awarded damages against Viennes in the amount of $365,000. 50 of that was on the unjust enrichment claim. The jury found only 50, even though we were seeking 100. And then they found 105,000 trebled at 315. So 365 was for on those 3 claims against Viennes. Then the judge made the conclusion that there was a fraudulent transfer, and that conclusion was based upon the admissions of Viennes at the trial in this case, that he conveyed the $40,000 to his company without any consideration. So that on top of that would be a total of 405. If you look at the 40,000 just on the 315, it would be a double recovery up to the 40,000. It wouldn't be a double recovery unless it was collected though.
But I guess isn't that the problem that at least appellant says, look, the way this judgment is written, your client would be entitled to an extra $40,000.
Yes, and I agree with that. That if it was properly worded, that judgment should have said joint and several. That CT Trees was jointly and severally liable.
I guess I'm trying to figure out what you think the remedy is. Does the appellant just simply have to trust that your client won't attempt to collect the extra $40,000?
No, I think there's 2 remedies, Your Honor, that could be taken. One could be that if in fact we got our judgment satisfied by the defendant Viennes, for the full 365 plus the interest, then CT Trees could make a motion to exterminate their liability under the judgment. That's a first remedy that could be taken. Alternatively, if
Wouldn't the judgment need to say that that 40,000 was joint and several though, as opposed to seemingly a separate amount?
that was going to be my second remedy. If your honors thought that that was the proper remedy, you could remand with instructions to correct the judgment to make the 40,000 that CT Trees is responsible for to be jointly and severally liable, so that when it is satisfied, there is no liability then on CT Trees. That's how the joint and several liability would work. So those are the two options. If your honors believe that it needs to be corrected now, then it would be an instruction to the lower court to correct the judgment, to read appropriately. But other than that, and if there's nothing else, I think the one issue though that has to be focused on here is that the testimony that was presented at trial was a full day before a jury. They heard everything on all of the claims. And the one piece of information that the judge excluded, which was the 500,000, is not really material. And if it is, it's harmless for him to have excluded it. I don't think it was improper to do that. But I also think we need to recognize if there was something else other than the 500,000 that Mr. Viens and CT Trees felt that the jury should have heard or could have heard, they were required to proffer that into the record. They had several opportunities to do that. And if you read the record clearly, you'll see that Mr. Viens himself was arguing as to why this information should be included. His counsel didn't take that step, which if there was something so important that he felt was so highly prejudicial, he should have put it into the record then. The reason he didn't is because 4 times Mr. Viens mentioned the $500,000 amount. And it was only when he mentioned that number that the judge would bring us up to sidebar and say, you can't mention that. If you read Grace Atchison's testimony, it reads very clearly because there's no interruption at all. She didn't mention the 500,000, but she mentioned everything else. She mentioned that there was an agreement between the parties. She testified that the 100,000 was a bonus for Mr. Viens, which was a defense to the unjust enrichment claim. Then she testified that there was the agreement to create the racing team, and it was a 60% Viens, 40% ownership for Mr. Land. And then she testified that the truck and the hauler were purchased for the race team, that in fact they were titled in the name of the race team. That was the defense to the civil theft and conversion. Mr. Viens himself submitted bills of sale showing that the transactions, in his assertion, were purchased for the race company. All of this was testified to. The jury heard all of it. They were able to clearly defend the claims, but the jury didn't believe them. They got both sides of the story, and after hearing both sides, they entered a complete verdict in favor of the plaintiff, Mr. Land. And that judgment was entered, and the damages are correct. With respect to CT Trees, it could be modified and made more clear that their liability is joint and several with respect to Mr. Viens on that claim. Thank you.
All right, we go back to the appellant now.
So I'd like to briefly rebut some of the points made by opposing counsel. First of all, as for the affirmative defense, again, we maintain that this was not required to be pled because at no point did Mr. Viens admit liability of the elements of the claims against him. He vigorously denied Mr. Land's actual ownership of the truck and trailer, and he denied a felonious intent, meaning that he knew that Mr. Land owned the truck and the trailer. And so he never admitted liability and then sought to justify it in some way. Rather, he simply denied liability.
For an affirmative defense, you don't always admit liability. I mean, one of the examples you used was contributory negligence. You don't have to admit that you were at fault to plead contributory negligence or comparative negligence, even though it's an affirmative defense. You don't go, yes, the wreck was my fault. anymore here, but I mean, he's explaining his conduct. Yes, I took the $100,000 and put it in my own bank account. Yes, I took the money from selling the truck and trailer because of this deal. So, you know, that's what I don't understand, why it's not an affirmative defense.
It's not an affirmative defense because he wasn't attempting, in the contributory negligence example, generally the way it works is you say, I may have been negligent, but he was more negligent than I was. If you want to completely deny negligence, you don't need to plead the fact that you were not negligent. So to the effect that you're admitting that you were somewhat negligent, but the other party was more negligent, then it's an affirmative defense. But if your defense is simply, no, I was not negligent, then you're negating the elements of a negligence claim, and that's not necessary to be pled, as far as I understand.
But in terms of explaining his story, other than the $500,000, what was Viens prevented from doing? He was able to testify about the deal, and he was able to have his other witness testify about the deal. Not that he broke into the thing and defrauded him of $100,000 or $205,000.
I think that the testimony, for example, of Ms. Aitchison should be looked at closely, because nowhere did she testify during trial. In her affidavit, she testified as to the fact that the truck and the trailer was part of the race team and were a buy-in towards Mr. Land's investment. But during trial, she did not testify that. In fact,
But did she try to testify to that? I mean, was that proffered? Was it brought out? Was it objected to?
there was before her testimony, opposing counsel objected and said, I want to exclude kind of preemptively any mention of the $500,000 oral agreement that was summarily adjudicated.
So we're not talking about the $500,000 number. We're asking you about all of the other, the fact that there was an overall agreement to start a race team, et cetera, not the 500,000.
She never testified to that. And
was she asked to testify to it?
I think what happened at trial is the $500,000 was a stepping stone to a discussion of how the overall agreement worked. And the judge throughout the trial didn't simply exclude references to a $500,000 amount. He specifically said there's not to be any discussion of a larger investment.
No, that's the counsel. That's not how I read the transcript in numerous places. Can you tell me what page of the transcript I missed?
Yes. On page 144 through 45, the judge says that asks if the defendant understands that he's not presenting evidence of an oral agreement that has already been disposed of on summary judgment. On page 346 through 347, the judge, well, that involves the amount. On 346 through 347, the judge says any issue as to a larger investment isn't an aspect of this case. So after numerous categorical exclusions.
Again, referring to the $500,000 number, correct?
Referring to an overall agreement. That's
no,
how.
The trial. Okay, I'll look at those page numbers, but every single time I checked the transcripts on the pages you cited in your brief, it was pretty clearly directed to the $500,000 number. But you say page 144 and 45, I should look at it again.
And 346 or 347.
Okay.
All right, and you're out of time. Thank you very much. We are adjourned for the day.
Thank you, Your Honor.
Judge.
Thank you.